Hey guys, sorry about that. It took a couple minutes. Um, yes, cat in a box. Yes, POV of a roving cyclops. Hey guys. So took me a little longer to whip up that thumbnail than I thought it was gonna take. So my apologies. My apologies there. I thought I'd be done sooner than I would. Um, so this one actually, I do want to get some. I do want to make sure we get some viewers in on this one because this one's going to be pretty good. So the long and the short of it is, for Richard Allen, he got his attorneys back. I know you guys. We've covered that. Life is good for Richard Allen. He got what he wanted. He got his attorneys back. Life is good. Rozzy and Baldwin are back on the case, and they've been putting in some work. And as we covered earlier, Judge Gull has also had her hands busy at things now. What do we learn Judge Gull did? Well, Judge Gull's done a couple of things here as far as, well, I mean, we'll call it monkey business. She immediately said, "Oh, hey, all those things you guys worked on, yeah, don't count, don't care." Uh, Very surprising in that regard. Um, in that regard. So what's going to happen from here? I don't know. Um, is Judge Gull? We don't know we don't even know what the opinion says. Like, is the Supreme Court of Indiana going to say this couldn't have happened at all? Period. Judge Gull shouldn't have done it. We don't really know that answer yet, and that's a bit of a problem for us, on this side of the world because what's going to happen here? Is she going to allow them to continue as attorneys? Is she going to try to still fire them? Um, she's still going to try to kick him out. I mean, she could still do that technically, unless the Supreme Court says like, no, you already messed up that chance. Um, so I don't know what's going to happen there. But I can tell you, um, hold on, guys, I need to finish the description here. So, what has happened since then? Well, Judge Gold denied all the motions. Basically, she's kind of fucking everything up, more or less. So, Rosny and Baldwin went ahead and filed motions to disqualify Judge Gull. They also did something through Richard Allen, a affidavit that outlines all the reasons why he wants Judge Gull removed himself. So, and that's all part of the package they put together. And this is effectively, and I probably think is the best answer at this point. And tomorrow, when we talk to Kara Weinke, the attorney out of Indiana, one of the attorneys in Indiana who's been helping Richard Allen deal with everything, what is the right options? What were the right options? What's the right idea? What is the best idea? I think we're at that point where they've got to do this. They've got to lower the boom and go after the judge in a legal sense because she's acting like a crazy person. So much of this case has been ruined from Richard Allen's standpoint. Their ability to, my mic's choppy. Hold on. Is this better? Let me know. So we've got to find out what happened there. And I think, was that a Cheez-It? No, it's a piece of an orange. The mic is perfect. All right, good. So we're kind of running out of options here for Richard Allen's team. I mean, the judge, by doing all this, basically imploded his ability to have a fair trial. They were going to go ahead and do a trial. The trial was already supposed to be happening. But because Judge Gull got a bug up her butt, and I've said this and I keep saying it now, whatever it is that's going on with Judge Gull, it's gonna be a stupid reason for her to do all this, and I still don't know what the reasons are. We still don't know. But I can only imagine whatever reasons and logic she has are completely moronic, and that's only just going off of why her actions are what they are. So, also, if you guys were wondering, Rumble should be live too. If you guys were curious, she has dementia. And she thinks she's Judge Dredd. No, I just think she's just. I think there's an issue of wherever she's at. She thinks she's like the top dog, and from what it sounds like, this is how they do things out the way she's judge. It's how they do things out her way, which isn't a good thing, but we'll deal with it. We will deal with it. So, without further ado, there's like 77 of you here. Let's just get going. Let's get going on this. She didn't get the Callie Award, but Rossi did. That That's a law school joke for you guys out there. That is very funny. You're a funny guy, Sully. We got something for that.
You're a funny guy, Sully. I like you. That's why I'm going to kill you last.
Just be careful. Watch yourself out there, Alpha. More like Judge Gull. Am I right? Yeah. A little bit. So let's get started with this, and let's just dive in. A couple things were filed. Now, we'll do the first thing. This is certification from Richard Allen's attorneys, Brad Rossi and Andrew Baldwin, and they're saying that they believe in good faith. The facts recited in Richard Allen's affidavit are true. Now, I know some of you are saying, wow, why are we doing this? And I'm like, well, I need to make it somewhat suspenseful. So they believe in good faith, and it's funny because, they write it here, and I will say Brad Rossi and Andrew Baldwin, those are some very flourishing signatures. Very flourishing signatures. And we'll talk about what I think those mean in a second here. Now, where are we going to start? We're going to start with this. This was filed January 28th. So as Judge Allen was out there doing her nonsense, well, Richard Allen's team was not sleeping. She didn't catch him slipping. A verified motion to disqualify. And they're bringing this is by Rossi and Baldwin, and they're bringing this pursuant to the Indiana Rules of Criminal Procedure. And they respectfully move for a change of judge from Judge Gull or her recusal from this cause. So, they point out that this filing for a motion or disqualification and or request for recusal strips the court of jurisdiction to decide any matters until a ruling on the disqualification motion occurs. And that's true, because once you bring this up, and that's not uncommon to really anywhere. That's pretty much everywhere. I mean, I doubt it's different anywhere else you can go in the world. Well, in America, in Ohio, if you do that in Ohio, so here's the cause to disqualify. It's by Rossi Baldwin. Everything is on pause until this is done, and that's pretty normal. If you don't do that, obviously you have a problem. So, also pursuant to the rules, they say the state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The affidavit must set forth the facts and reasons for the belief that bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorneys must file certification. The attorneys believe in good faith. Those facts are true. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. Now, this is interesting because in Ohio, if I want to file a motion to remove or recusal, there is no standard procedure, and this isn't. There's no setup like this. So this is very interesting. And like I said, every state's different, and I will say this is kind of neat for Indiana. I really think this is pretty cool. Or they say, put another way, the facts in the affidavit must show there's a reasonable basis to question the judge's impartiality toward Richard Allen and his defense team. And I think based on what's happened so far, there's a reasonable basis to question her impartiality, given her just like psychotic behavior at this point. Yes, Judge Gull, if you're hearing this, like you're acting like a crazy woman. Like, honey, stop. Stop. STAHP. Stop. Stop doing this. They point out that in addition, alongside that, there's Rule 211 of the Indiana Code of Judicial Conduct. And that's the thing. Judge Gull is bound by the rules of professional conduct for attorneys, but then she has a secondary on top of that, the rules of judicial conduct, the Code of Judicial Conduct. So she's got two rules of responsibility she has to abide by. So they require a judge to qualify themselves when the judge's impartiality might reasonably be questioned. Yeah, this is pretty reasonable given what's happened so far. The fact she denied their Frank's motion, their motion in limine, their motion to suppress, like 200 pages of motion practice, just with a nope, not doing it. That questions her impartiality. The rule on disqualification and the canon on recusal, and a judicial canon is another judicial guideline. Things are supposed to follow. They both adopt the threshold of reasonableness. Would an objective person have a reasonable basis doubting the judge's impartiality? And that's the thing. Does a person from the outside, it's not a reasonable judge. It's would a reasonable person have a reasonable basis to doubt the judge's impartiality? So a guy walking down the street, or like you guys, would you have reason to believe this judge is not being fair? I think you'd say, yeah, 100%. So, Unhung Hero for $2 says, thank you again, man. Saying, I'm going to come. Hold on. I'm going to come. Don't come. Don't come. Replay crew tonight. Have fun, guys. Well, thank you. I appreciate it. So that's the standard here. There's also comments, and all of these rules and everything else, there are comments, and the comments are meant to further kind of outline and explain what's going on. So in the rules of criminal procedure, there's comments. The rules of evidence, there's going to be comments. There's comments usually to everything in legal rules and things that are organized, because it helps explain things. And in this case, the Indiana Judicial Conduct Rules were probably promulgated by the Supreme Court or a panel the Supreme Court put together to come up with them. Well, the comments generally explain the reasoning or further explanations of the rules. So they point out additional guidances under the rule. Judges disqualify whenever the judge's impartiality might reasonably be questioned, regardless of any of the specific provisions of paragraph A1 through A6 apply. In many jurisdictions, the term recusal is interchangeably used with the term disqualification. A judge's obligation not to hear or decide matters on which disqualification is required applies regardless of whether a motion to disqualify is filed. And then they talk about comment 5. A judge should disclose on the record information the judge believes that the parties or their lawyers might reasonably consider relevant to a motion for disqualification. Even the judge believes there's no basis for it. And that's something judges always have to do. A judge may come in, I've had hearings before, civil and criminal, where the judge comes in and says, hey, I just so the record's clear, I represented this kid's dad. Like, there's a judge I've been in front of recently. He's like, yeah, when I was practicing, when I was in private practice, I represented this kid's dad on a bunch of criminal stuff and also his divorce, which the defendant was one of the kids on. The judge says, I don't think that's a problem, but I give that to you guys and you guys can have some time to talk about it. And I looked at the prosecutor and I'm like, I don't have a problem with this. And I looked at my client. I said, do you have a problem with this guy being your judge? And my client said no. And I don't think it was a conflict of interest in any way, but it's something the judge like, hey, you guys can figure it out if you guys don't want me here. And the judge said it. He's like, if you guys have a question about it, you don't like it, tell me and we're out. No harm, no foul. So the test, and they go on further. The test under the canon is whether an objective person knowledgeable of all the circumstances would have a reasonable basis for doubting the judge's impartiality. The question is not whether the judge's impartiality is impaired, but whether there exists a reasonable basis for questioning the impartiality. So once again, the appearance of impropriety is enough. There doesn't have to be a conflict of interest. There doesn't have to be impropriety. Does it appear to have impropriety? Does there appear to be a conflict? And is it reasonable? Yeah, I think there is one here. This legal standard. I love how they just put this at the end. This legal standard is not lofty. Yes, they're pointing out that is a very low level standard. And that's an impressive standard to have because that's a very easy one to meet in most cases. The accused, and that means the defendant, and that in this case Richard Allen, has a federal due process right to an unbiased judge under the Fifth Amendment and the 14th Amendment of the U.S. Constitution. You're entitled to a fair trial and a fair judge, an impartial judge. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error. And structural error means it automatically comes back, new trial. Like there is no harmless error. When it's structural error, it's completely deficient. It's completely broken. You can't get around it. There is no, it's completely garbage. So that is what happens with that. Case of judicial bias involve a denial of the most functional constituents of due process. So fundamental, I don't know why I had these on. So fundamental that a conviction in their absence is indecent if the defendant is plainly guilty. And this is the pointing out, the structural error is so fundamental that if due process, even if they're guilty as sin, we'll use Ethan Crumley as an example. He 100% did it. But if there was a structural error in his case, it has to come back no matter what. And that's the point. A structural error is so critical. You can't ignore it. I mean, it's like a house. You can't paint over it. You can't shore it up. No, the foundation is garbage. It never was working in the first place. There are no I-beams in the middle of the house propping it up. No, the house is a write-off. You have to tear it down and start over again. That's what a structural error is, and it's a real problem. It is a real problem. And Judge Gull has created that problem. Structural errors render a criminal trial fundamentally unfair and not subject to harmless error analysis. That's been the case for a long time. Here, there is no recognizable legal rationale which supports Judge Gull continuing to preside over this case. At every stage, from now until the conclusion of this case, the actions and rulings of the court will be scrutinized through the lens of Judge Gull's error in severing Allen's attorney-client relationship with his chosen lawyers. And that's true. That was such a big thing. I mean, everything's going to be filtered through that. There's no other way to look at this. The preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. I have not read this. I'm reading this along with you guys. First time, okay? And I can already tell this court has interfered, and this is already going to be some fire. This court has already interfered with one of the most sacred concepts in our Constitution. The relationship between attorney and client. Ooh. Preach. There can be no dispute that this has occurred. The highest court in the state of Indiana has cemented this fact. If the Supreme Court of if the Indiana Supreme Court concluded that Judge Gull wrongfully denied Richard Allen of the attorneys of his choosing, wouldn't then an objective person have a reasonable belief that she, Judge Frances C. Gull, is biased and prejudiced towards defendant Allen? Yes. Wow, these guys are not fucking holding back. I mean, I think I said it when they came back on. God, whose stream was I? Were they on my stream when I had David and Kurt on? I'm like, these guys are like, I said it, as soon as they get back in there, they're sharpening their fucking knives. And man, homeboys put a nice edge on their knives, and they put to work. Judge Gull should recuse herself, and in doing so, restore any sense of impropriety that is clouding the system of jurisprudence in the state of Indiana and this very proceeding because of the judge's prior actions. Ooh, these are spicy. The recusal of Judge Gull would be entirely consistent with the spirit and foundation of Canon 1 and Canon 2 of the Code of Judicial Conduct, both of which are founded in the concept of judicial impartiality and fairness. Judge Gull continuing to preside over this case necessitates that the following questions be asked. Will Judge Gull's continued involvement create built-in reversible error in the event defendant Allen is convicted of any one or more of the charged crimes? Will all future rulings of the court be viewed by the defense as being tainted with bias, prejudice, and a lack of impartiality? Will the public maintain, and this is a big one, maintain any sense of confidence that the presiding judge is unbiased and impartial? I mean, that's a massive one. Say what you want about Richard Allen. You don't like him. You hope, you think he did it. Do you look at this and feel confident that this judge is playing it straight? Do you feel confident in the system? Can Judge Gull process any information or legal arguments offered up by Rozzi or Baldwin, knowing she's already made an extrajudicial finding that both have demonstrated gross negligence and gross incompetence on the representation of defendant Allen? Yeah, I mean, that's a big deal. She's already gone outside the rules already and determined these guys suck. I mean, because what else would you call gross negligence and gross competence? That they suck. So how can she have any, objective feelings towards them? There's nothing there. That's a shame, says they're fucking warriors. These guys are, yeah, I mean, this is just like, they're putting this together. I'm reading this in my head. It's just like, bring them out, bring them out, bring them out, bring them out. Like, yeah, these guys are, ooh, I said this before. Rozzi and Allen these guys are fucking battling for Richard Allen. These guys are going to the max. Yeah, they're warriors. I mean, they are willing to go they're willing to go set this shit on fire. And I appreciate it. I appreciate it. Does Judge Gull have some ulterior reason or motivation driving her unwillingness to recuse herself from the case? Normally you wouldn't do this. Normally you wouldn't do all this. I mean, you'd figure out a way to make this very, very nice because you don't want to piss off the judge. But at this point, what else can she do? She's already gone full retard. There's no stopping the woman now. They're loading up the elephant rifle. They're just going straight at it. Some Hemingway stuff like the snows of Kilimanjaro. They are not afraid. Do the practical benefits of recusal, part F, the practical benefits of recusal far outweigh the inherent risks of Judge Gull remaining on the case, especially as it relates to the likelihood of protracted and expensive litigation throughout the remainder of this case at the appellate courts if a conviction occurs? Yeah, this is going to go on forever. And not only that, but if she starts denying stuff, this is going to get run right back up the flagpole to the Supreme Court of Indiana. Every time she does something. Accompanying this motion is the affidavit of Richard Allen setting forth the facts and reasons why defendant Allen believes that a rational basis for questioning the judge's impartiality exists. Wow, that came out and set like, ooh. Okay, this must have been faxed back to him. Okay. Same affidavit sets forth the timeliness and request for a change of judge. It's also certified. Let me talk about certification of good faith. Now, if you guys look at this right here, that right there and that right there, those are big fuck you signatures. Those are big ass fuck you signatures. That's like Declaration of Independence style. Like, yep, motherfuckers, come get me, British. I signed this thing. Fucking come after me. Both these guys just signed big old fucking, when I write, I write it, and I try to stay, you try to stay within the lines right here because it gets a little obnoxious. But Baldwin and Rozzi are both just, you know what? Fuck you. I'm sure it was more like this, actually. They're just like, fuck you. And let the pen go across the room. This is, yeah. Kaz, I hear him. Kaz, like, I call cap on the judge. Yes. Do we get TikTok in Outer Heaven? So there's a couple things here. Ariel says, how do you feel about it being Judge Gull that gets to decide this? I mean, there's really no other way to do it. You have to go through the judge in your case. That's always how you do this. I wish there was a better way, but I don't really know you can have a better way unless you have like a judge overseeing that judge, and that's just not wouldn't work that way. Aaron saying Caesar's house must be above reproach. Yes, it should. Alpha Fox saying, "Oh shit, do they hit a taints jury pool argument?" I don't know. We'll have to read what Richard Allen's affidavit says. Awareness of the case equals awareness of the rulings against the judge necessarily. Yes, it does. Especially how big this has gotten. Alpha Fox again is saying it would almost make their case if she fails to recuse. Depending on how she responds, this is a fucking trap, and I dig it. Yeah, there's something, these guys, I will say this much about them. I don't know anything about them, but yeah, I wouldn't be surprised if this is just one step. And I don't know what those attorneys out there in Indiana are doing, because it's not just Rozzi and Baldwin. Parts of the Indiana Public Defender's Office have gotten involved. And like I said, tomorrow evening at 7 p.m., we're going to have Kara Weinke on. I don't know. I don't think she's involved in, what may come again, unless something happens. Then I assume she'll jump back in the fray. But I assume there's some plotting and planning, getting ready. Like, these two guys aren't just doing this on their own right now. There are a team of attorneys probably wargaming this and prepping themselves in case Judge Gull doesn't do the right thing. But yeah, people are ready to go, man. And that much I can say for sure. Cass says, no, I banned TikTok. It's vapid Chinese AIDS. Yes. Jim is saying a lot of chicken emojis. I'm not sure you're calling Judge Gull a chicken, but maybe. Okay, let's see here. Also, that's James says, what, I'm not getting notifications? Yeah. Well, sorry. YouTube's afraid of me. What can I say? I'm a bit of a big deal. Okay, where are we? Rage Star says the prosecutor needs to go also. He's getting that way. He's cruising for a bruising, but he's probably not going to get kicked out. That is really, really hard to do. So that is really hard. But now the bigger issue is, what did Richard Allen say? Because remember, you have to include an affidavit from your guy. And Jim said, Tilly says the right side circle is bigger. Yeah, the right one's bigger than the little one. Bella's saying, so how are we pissed at the Crumley verdict? Yeah, it's an absolute travesty of justice. Absolute travesty of justice. Completely disgusting. So, yeah. But we'll see what happens. A Wonderful Galaxy said Josh ended. Hi. Well, hello. All right, guys. So let's get to what Richard Allen talked about. Yes, Jennifer Crumley was found guilty, all counts. Chastarian Fraud says, do most judges view recusal admitting that they are biased? No. There are times where I've had judges where, one of the parties one of the parties being sued had a lot of interactions with the judge, had business dealings with the judge. It's not admitting bias. It's just like, look, even, and I had a civil case where, the judge had a business dealing with the family of one of the parties involved. And he said, look, I'm going to bail on this because I don't even want to question it. He said, I'm not biased. And we understood that. He wasn't. He's a very fair judge. I don't think that would cloud his mind at all. But for the sake of propriety, he pulled the handles and ejected. Fair enough. I totally get that. It's something that honest people do, and it's what honest people should do. They think there's an appearance of impropriety. Say, look, I get it. I'll show myself the door, and it got assigned to a new judge. So it's not necessarily, you're not admitting anything there. Real quick, a Wonderful Galaxy saying, have you ever done a trial that was televised? No, and I thank God for that. Oh. So let's move on to what Richard Allen's comments are on this. So we also have filed on the same date, January 28th. Same date, same time, right there. From Richard Allen, and it's his affidavit talking about all the concerns he has about Judge Gull. When was this filed? The 28th. So now comes the affiant, and the affiant is the person who swears out an affidavit. And he swears or affirms that the following statements and reasons for disqualification are true and accurate. As I have either personal knowledge or have learned of these facts and reasons through my counsel. And I bet it chaps Judge Gull's ass, Brad Rossi and Andrew Baldwin. Number one, and we've got 22 pages, so there's a lot here. There's a lot of good stuff. Judge Gull interfered with Richard Allen's attorney-client relationship. On October 12th, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying the timely, effective representation guaranteed to him by the state and federal constitutions. And it's true. When she told them to quit working, well, they weren't representing him anymore, and that was unfair. You notice there's a little footnote down here. What are they saying? This directive by Judge Gull was included in an email dated October 12th from Judge Gull to the attorneys and the prosecutor. Okay. This disarming of counsel also occurred immediately in advance of Judge Gull ordering up a hearing in her own courtroom in Allen County, Indiana. At the hearing, Judge Gull staged the premeditated removal of attorneys Rossi and Baldwin, complete with cameras in the courtroom for the first time ever in this case. Now, I will bring up something, and I don't know if you guys have, I don't know if you guys are getting here. Richard Allen didn't write this. Richard Allen signed off on it. And that's all that matters, because as far as an affidavit goes, I can prepare affidavits for people and they can sign them. So you can't do it. You can't sign over the telephone, though. Can't do telephone notary. But if I write an affidavit for you, you can sign it. And because for example, in Ohio, I'm a notary because I have a law license. I can notarize that signature and notarize the affidavit. That's valid. Richard Allen doesn't have to sit there and type it all out or take one of his, where'd my stabby jail pen go? The floppy jail pen, and sit there and try to write it all out on a roll of toilet paper while the Odin guards are trying to kill him. That's that is where things are. So the attorneys wrote this, and you're going to see, I have a feeling we're going to see a lot more fire, because I'm already feeling that. I'm feeling that vibe. I am feeling that vibe right now. So here we go. With Judge Gull having prepared in advance the handwritten statement with claims of grossly negligent and grossly incompetent actions on the part of each lawyer, which she did do. Judge Gull publicly and on the record disparaged defendant Allen's chosen attorneys. The week before the October 19th hearing, Rozzi and Baldwin asked Judge Gull what to expect at the hearing. Rozzi and Baldwin knew from the October, they said, 10th phone call that Judge Gull had come in and she was inclined to have them removed at the request of the prosecutor before any hearing had taken place. Removed from the case before any hearing had taken place. Just, listen to the judge thinking of that. She was inclined. I'm inclined to screw everything up. I mean, does she do this all the time? This is not normal, guys. Even though it's in a different state for me, this is not normal. Before researching the issue or having any meaningful chance to consider the request, between the October 10th phone call and the hearing date, Judge Gull prepared a scripted statement that would otherwise be used as her basis for finding Rozzi and Baldwin acted grossly negligent and with gross incompetence in their duties as Allen's lawyers. It should be noted that Judge Gull later added to her list of allegations that attorneys Rozzi and Baldwin also violated the rules of professional conduct. They do this. Oh, this is. These men have a fucking axe to grind against Judge Gull. Oh my God. It is noteworthy that Judge Gull makes these claims despite her own appellate attorney acknowledging to the Indiana Supreme Court that Rozzi and Baldwin were very experienced and highly competent lawyers in all other aspects for their alleged incompetency and grossly negligent acts in these cases. These contrasting facts are hard to reconcile. Oh my God, we got 20 more pages of this. They're going to fucking ream her out with this. Judge Gull, Frankie, honey. You about to get hollowed out on the internet, girl. Mature brunette gets hollowed out by two Chads. That's what this is. While entire nation watches. Whoo! Lord child. All right. There exists a rational inference of bias or prejudice because Judge Gull formed this opinion. Worse yet, Judge Gull claiming on the record in chambers that she is finding gross incompetence on the part of Baldwin and Ross. He provides a rational inference of bias and prejudice. It does. A judge has predetermined an attorney is grossly negligent and grossly incompetent has developed a bias towards that attorney. Very true. The mere reference to Rozzi and Baldwin being incompetent would be strong evidence of a rational inference of bias and prejudice. But claiming that she, Judge Gull, finds them grossly incompetent provides even more conclusive evidence of a rational inference of bias and prejudice. Judge Gull telling Rick Allen that she has grave concerns about Baldwin and Rozzi representing him provides a rational inference of bias and prejudice. So let's see what the footnote's about. Let's get this footnote. Judge Gull spoke these words to Richard Allen at the courtroom. And we remember we had that, that was that hearing. I have grave concerns. Yeah, so concerned. And finally, Judge Gull, for the first time ever, allowing cameras in the courtroom, knowing her plans to ambush the defense and how cameras in the courtroom would impact the attorneys psychologically and also professionally as they tried to process their options, provides a rational inference of bias and prejudice. Yeah. Psychologically, but also professionally and ethically. Because one thing if a reporter just writes about it, but if we all watch that happen, yeah. Judge Gull violated Richard Allen's due process rights. Yeah. After she ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. And the choice presented was to suffer a public shaming at the expense of Rick Allen and to be removed from the case or to voluntarily withdraw in the face of compromising Rick Allen's defense strategy. Despite defense counsel requesting clarification as the topics or motions to be addressed at the 19th hearing, Judge Gull gave defense no notice of her plan to force withdrawals or remove them, thus denying the opportunity to adequately refute her accusations. Judge Gull's failure to offer up to the defendant or his counsel the basic due process the law creates a rational inference of bias or prejudice towards he and his attorneys. Very true. Let's see here. We're going to get... Oh my God, this didn't... Oh, God damn it. Fuck me running. How far did we get before you guys see this? Okay, so... Yeah, they are just lighting her up here. They are just lighting her up. This right here, guys, this noteworthy about the claims. Yeah, this Judge Gull is toast. I don't know how the Supreme Court of Indiana is going to look at this any other way at this point. Because this woman has completely screwed it up. I'm sorry, I didn't see that was not there. Bella says, do you think we give Sean hell or protect them? You guys wouldn't. I'd be fine. A Wonderful Galaxy says, Lamau, Sean doesn't want all his mistakes pointed out. I mean, what we do is voyeurism at the end of the day. I don't want to be voyeured. Okay? It's nervous enough doing my job and knowing that everybody I deal with is watching me. That would just be, being part of the peanut galleries watching me would just make it even worse. Zaven says, shouldn't she have recused herself already? One would think, but I don't. For this woman, I don't think recuse is a word in her vocabulary. That's a shame for $4.99. Thank you very much. The support says, go off, Kings. Yeah. Yeah. King, salute, and unbreaded. Costco parking lot romance. I understand that reference. I hope Richard Allen's attorneys know better than to put a 26-year-old single mom hairstylist who has a nose ring and clown makeup on the jury. Yeah, they do. Yes. And Nico says, no Tyler phone notary? Oh, no, Lasagna Bros. We lost again. Alpha Fox says, that's why you need DocuSign. Well, there's no DocuSign at the prison. That's a shame, says he could have also given them a gist and they spruced it up. Sure. They could have. And that's a shame saying, let's fucking go. Yep. I'm not sharing. Okay, share screen, yes. Yes. Yeah. That's a shame, says she's finna get cracked open and cleaned out. Well, like I said, mature chubby brunette gets hollowed out by two Chads in an office setting. What's going to happen there? Share screen, please. Yeah, I'm working on that. What are you guys saying, Bruce? What? We would create many memes, yes. It's Trenton saying the Supreme Court gave her the chance to bow out. She chose, yes, she chose her own fate. Yeah. Zavin saying 22 pages ago, how long till I see? Well, I'm seeing now. Squeaky Wheel saying, I heard in a couple of different places that Rozzy expressed somewhere in that motion he was worried about being arrested. Anybody know what that's about? Well, it could be contempt, but it could also, any number of things at this point. The police, like in their investigations, maybe want to arrest him. Who knows? I wonder if Galaxy saying, are we in mistrial territory? Not yet, but we are approaching the rocky shoals. The rocky shoals littered with sea mines everywhere. Littered with sea mines and coastal batteries pointing off the cliffs with spotlights ready to rock. we are slow. We are fast approaching that. We very easily can end up there. Now, I'm not saying we're adrift and without power in the middle of a nor'easter and just like floating around, but Judge Gull is not doing very good at the navigation because she has a map. She knows how to avoid all of this. One would think. And she's apparently like, whatever. She took that map and made a little sailor hat. So we're going to keep going on this, guys, now that you can read it. That same day, Judge Gull prepared a statement she threatened to read to the public, alleging defense counsel was grossly negligent and incompetent in the representation of defendant Allen. Judge Gull's complaint was more about not having control over counsel, and that's the point. She wanted to be... Judge Karen wanted to be in control rather than any legitimate concerns that counsel had been engaged in conduct that compromised Richard Allen's defense. Judge Gull cited a number of different concerns, none of which formed a basis for the removal under Indiana law. Thank you, Indiana Supreme Court, on that one. Additionally, until the in-chambers hearing, other than the topics of the evidence leak, Judge Gull had never before mentioned to counsel that the other items she mentioned in chambers were worthy of them being disqualified from the case. There's no way defense could have been prepared to refute or argue, for example, Judge Gull's apparent belief that Brad Rossi's filing of a tort claim notice to protect his client's rights was one reason that Judge Gull thought defense should be disqualified. Judge Gull provided no preview of the topic she intended to discuss, which caused her to disqualify Allen's attorneys, other than the leak, and certainly never told the defense that she had already made up her mind to remove them from the case. In other words, the majority of topics Judge Gull raised with defense as reasons for their removal at the in-chambers hearing were a complete surprise to defense. What happened in chambers was a violation of Richard Allen's and his attorney's due process rights. Accordingly, the Indiana Supreme Court ruled that Judge Gull's actions in removing Baldwin and Rossi were in error and reinstated Baldwin and Rossi as Richard Allen's appointed public defenders. This reversal of Gull's removal and refusal to accept their appearances as pro bono lawyers took place very publicly over the course of intense litigation, putting Judge Gull on one side and Baldwin and Rossi through their client's original action against Judge Gull on the other. Yeah. You guys remember it was State ex-rel Richard Allen versus Carroll County Court. Is Richard Allen seeking a writ of mandamus against Judge Gull for his attorneys. Judge Gull chose to retain counsel to fight the original action. The highly public and contentious litigation between Judge Gull and Rick Allen, and therefore between Gull and Baldwin and Rossi, provides a rational inference of bias and prejudice. Judge Gull engaged in critical stage proceedings in defendant's absence. Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available to participate in the hearing. And it's true. Well, I don't want him here. It doesn't fucking matter. He has the right to be there. And, I don't like attorneys in my chambers. Too fucking bad. You brought all the cameras in, so there's nowhere else to go, honey. Placing his attorneys in an ethical dilemma and creating a public record outside the presence of the accused. This ignored any sense of due process and violated rules 1.2 and 2.2 of the Code of Judicial Conduct. Judge Gull failed to maintain impartiality and fairness. Judge Gull engaged in a planned forced resignation of the defense team in her chambers on October 19th. Judge Gull again referenced defense counsel's pleadings that contained, in her words, inaccuracies and falsehoods, yet parts of it were true. The court's references were connected to facts and circumstances surrounding the emergency motion to modify the safekeeping order that was denied by the court on the same day. The court instructed the Indiana Department of Corrections staff to stand down on the transport of a subpoenaed defense witness. The court's own actions were and are prejudicial to defendant Allen's defense. And that part right there is true. She did that. She told them, don't transport a prisoner that's been subpoenaed. Why? Well, I said so. Judge Gull's belief that counsel provide false pleadings to the court, thereby questioning their integrity, exhibits a rational inference of bias and prejudice. And here's the other thing, and I brought this up before and I keep bringing it up. If the judge thinks they violated the rules of professional conduct, she has an obligation under the rules of professional conduct to report that misconduct to the governing authority, which in this case would be the Indiana Supreme Court, I'm pretty sure. She has to report it. If there is misconduct, she has to be involved. She can't just say, oh, well, these two chuckleheads are screwing it up. I'm getting rid of them. No, if they broke the rules of professional conduct, you'd better report them. If you think they did, you better report them. Notice she hasn't done that. Apparently, she didn't think it was that bad, because if she tried to report this, the Supreme Court would look at her and say, are you fucking retarded? Nothing bad's happened here. But she made those threats and didn't follow through on them. So I would argue she's got an ethical issue of her own that needs to be resolved. And I don't know if they bring it up, but oh my God, I'd be hammering it on if I was these two. And hopefully, if Rozzy and Baldwin are hearing this, I hope you guys raise that issue. That she dare lower the boom of ethical violations on you and point out her own for not following through on it if she truly believed it. She's demonstrated bias toward the prosecution, finally. In the days leading up to the hearing, Judge Gull, Attorney Baldwin, Rozzy, and the prosecutor participated in a phone conference to discuss matters associated with the dissemination of crime scene photos. It was during this phone conference that McClellan, what asshole, uttered the first word of disqualification. Yes, and the prosecutor first said it. The prosecutor first uttered. After a very brief discussion, Judge communicated to the parties that she, at that moment, was inclined to grant the request. Really? The judge and the prosecutor's like, yeah, Judge, what about disqualification? You know what? I'm thinking about that. That's really impressive, because she denies everything from the defense. Hold on one second. So, without having considered a single piece of evidence, without defendant Allen being consulted, Judge Gull's conduct of quickly siding with the prosecution in an off-the-record phone call in a matter of such high importance, i.e., illegally kicking off lawyers who have spent thousands of hours on the case and would be prepared for the January 2024 trial date. Oh my God. You mad lads. Oh boy. Oh my God. That right there is a big fuck you. That is big. You guys want to see motions of big dick energy? Right there. That is big dick energy. That is big dick energy. I mean, cheers to you guys. That is, woo! Woo. Getting me a little hot and bothered on the collar here. So, this demonstrates a rational inference of bias against defendant Allen. Yes, it does. Judge Gull made public misrepresentations on the record. Immediately following the court's planned removal of the defense team, Judge Gull took the bench and addressed all those in attendance as well as the public at large through the lens of a pool camera, authorized by Judge Gull, broadcasting the proceedings to the general public and potential jury pool. In pertinent part, Judge Gull spoke the following words. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn the representation of Mr. Allen. The court concluded the hearing by stating, clearly this is outside of our control, which is a fucking lie, because you're a fucking liar, when referring to the events that took place in chambers. These words spoken are untruths, as the withdrawals of Baldwin and Rozzi were exactly what Judge Gull had pre-planned to happen. You know, honestly, that's actually an issue of she has a duty of candor still herself, so maybe somebody in Indiana should bring her up on ethics violations for a duty of candor right there and lying on the record. Maybe I'll bring this up with Kara tomorrow. I'm gonna take a note for that. Sanctions. Sorry, guys. Getting that note ready. Her words to the public, therefore, appear to have been intended to disguise her in-chambers actions, which forced their resignation. And Judge Gull knew her actions were wrong, and she later tried to conceal what happened in chambers. Oh my God. Oh my God. And that's true. She later tried to conceal what happened. When Richard Allen's original action lawyers attempted to obtain a transcript of the in-chambers hearing, Judge Gull's staff refused to access the transcript, calling it confidential. Richard Allen was therefore denied his right to the transcript of a hearing wherein he was not present and wherein his lawyers were effectively severed from him without his consent. God, I'm going to mail these guys some Burger King crowns. They need them. In order to review what happened in chambers on October 19th, Rick Allen's counsel sought the original action were forced to request the Indiana Supreme Court to order Judge Gull to release a transcript. And that had to happen. You know, Judge Gull's staff is like, sorry, we're not giving it up. And the Supreme Court said, hi, this is the Indiana Supreme Court. Yes, you're going to fucking do it. And guess what they did? Like housebroken little bitches. They coughed up a transcript. Allen's counsel made this request on November 6th. On November 8th, the Indiana Supreme Court ordered Judge Gull to release a transcript. And ultimately, Judge Gull complied. Judge Gull's attempt to deny Allen's lawyers a transcript of the in-chambers hearing and to keep that transcript hidden from the public provides a rational inference of bias. The court's own words to the public at the October 19th hearing, claiming the events were unexpected and were out of control, are in conflict with Rule 1.2 of the Judicial Code and support recusal pursuant to 2.11. I'm getting Twitter patted, yeah. Jack is saying, woo, pretty much. Apparently, Clyde is getting in trouble outside. I can hear him. Mr. Sniper muttered it. I like it a lot, but I think it's simply spelled mutered. Yes, for all the letters, good merch ideas for Sean. I'll have to work on that. Thank you, Tilly. David saying, this is so fucked up. Yeah, it is. Alpha saying the duty to report snitching rule of ethics most likely in the judicial rules of professional conduct. I don't think they're the judicial canons. I think she's just bound under the regular ethics rules. Kaz saying, whoops. Yeah. Uh-oh. Eric Fulham says the judge is an Otis. No, she's just an idiot. An idiotist. Oh. So Judge Gull engaged in ex parte communications. Ooh. On October 30th, Rossi and Baldwin filed their private appearances on behalf of defendant Allen as his pro bono attorneys. Once again, that was a brilliant fucking move. The next morning, Rossi and Baldwin appeared in person in the Carroll County Circuit Court as Allen's pro bono attorneys with the ethical and legal duty to carry out their representation of Allen. Yes. And anybody opposing that is acting unethically and illegally. Notice how they put that there. They're carrying out their ethical and legal obligations, and if you oppose them, you are acting unethically and illegally. My God, these guys are fucking amazing. I love this. I love these guys already. They're my homies. However, Judge Gull, with intentionality, refused to allow Rossi and Baldwin to carry out the representation of their client. This included communicating by text message. Really? Communication by text message to her chosen attorneys, the replacement ones, screaming in vibrato prior to the start of the hearing. And I'm assuming that these guys know about that because I'm assuming Screamin' and Vibrato, who actually appear to be pretty good dudes. I mean, they fully believe Richard Allen. They fully believe the Odinism angle and like all this they're like, it's all not nonsense. This is all legit. They believe he's innocent. Prior to the start of the hearing, this also included an in-chambers conference with said replacement attorneys and the prosecutor, while Baldwin and Rossi remained in the courtroom with their client. That's fucked up. After taking the bench, Judge Gull, on her own volition, severed the attorney-client relationship for a second time without seeking the opinion or permission from Richard Allen, the client. The sua sponte, meaning of her own accord, severance of the attorney-client relationship without the input or permission of Mr. Allen was prejudicial to his defense. The court's actions were not only violative of his rights, but also significantly impair any public transparency in the actions of the judiciary. Ooh. Oh, God, these guys, damn. Impairing the public transparency. My God. Could they be any more fucking brutal about this? The world would like to know. Oh, my God. The judge denied Allen the Sixth Amendment right to counsel, and doing so denies right to a speedy trial. And this part is true. Judge Gull denied Richard Allen the Sixth Amendment rights to counsel when she forced a resignation at that hearing. Rossi and Baldwin then entered their appearances. This was done at Allen's request. Richard Allen's intentions were to file a speedy trial motion and secure his previously scheduled jury trial date of January 8th. So he would have been done by now. Judge Gull prevented this from happening by refusing Allen of the attorneys of his choosing. Judge Gull's refusal to allow Allen's counsel of choice back onto the case effectively derailed any strategy Allen and his lawyers had developed in an effort to move his case into a courtroom and challenge the merits of the state's charging information. The judge's actions were per se prejudicial to defendant Allen, and that he was denied his basic constitutional right to the choice of counsel and also his basic right to a speedy trial. By extension, the denial of his right to a January 2024 trial date was prejudiced because he was returned to safekeeping within the confines of the same maximum security unit wherein he was unfairly detained and experiencing both mental and physical deterioration for nearly a year prior to this Sixth Amendment violation. And this is where he's been sitting with all those meth-eating hillbilly cousin fucker Odinist. That's right, I called you that, you fucking Odinist fuckers. I got Odin spear on my face. I'm sure you do. Is that what you guys call it when you're in the woods with each other? Now, no, we shall now pass Odin's spear from person to person. And, I bet if we looked at it, it'd be like, wow, that looks like an elephant walk. You'd be like, no, we're passing Odin's spear. Did I just call those guys homosexual? Yes, I did. Judge Gull changed her ruling in a prior order when attorneys Baldwin and Rossi were reinstated. This is a very good one. So, Judge Gull received the Franks memorandum from Rossi and Baldwin on September 18th. She took no action on the filing for over 4 months. She did offer her chosen public defenders, there's an extra period there, the opportunity for a hearing while they were representing Richard Allen. This is evident from her November 1st order, where she offered up the following invitation. They will await a report from the attorneys and the prosecutor regarding hearing dates. Okay. The court then memorialized this invitation to pursue these motions in a minute entry reflected on the case scheduling on November 2nd. Okay. And then again on November 14th, the court issued an additional minute entry again, inviting Allen's new counsel to set a hearing on the pleadings. That entry reads as follows. If defendant's counsel informed the court they intend to pursue the Franks motion, the court will schedule a hearing. 2 business days after Rozzi and Ball were reinstated, Judge Gull issued an order denying a hearing on the Franks motion, denying a motion in limine filed by Rozzi and Baldwin regarding the admission of ballistics evidence from the state. What appears to the defense to be a hastily written opinion lacks any serious legal and factual analysis on such an important issue. And they wrote a massive fucking motion. It was like 160 pages. The absence of any real or factual legal analysis contained in the order begs the question of whether Judge Gull actually engaged in any meaningful review of the memo and attached exhibits. And they're like, bitch, you didn't even fucking read it. They're saying either you didn't read it or you're Helen Keller. The timing of the ruling and the lack of serious legal and factual analysis provides a rational inference of bias or prejudice against Richard Allen. And most notably, Judge Gull offering her chosen replacement attorneys the opportunity for a hearing on the pending motions, while denying Rozzi and Baldwin the same opportunity, creates a rational inference of personal bias. It does. Judge Gull discredited Allen's defense strategy. On November 14th, Judge Gull issued an order that, in pertinent part, acknowledged defendant Allen's filing of a Franks motion hearing memorandum and support accompanying documentation. These documents had been filed on about September 18th, so like talked about above. Nearly 2 months later, Judge Gull, having taken no action on the pleadings, invited successor counsel to either adopt those pleadings or make their own. Implicit within Judge Gull's verbiage is what appears to be the court's attempt to empower her chosen replacements to abandon a material aspect of Allen's defense strategy. If there's any debate about the court's intentions, at the very least, Judge Gull's order and language therein creates the impression the court is skeptical of Allen's defense strategy, thereby prejudicing the totality of his defense. Accordingly, Judge Gull violated Rule 2.3 of the Code of Judicial Conduct. Judge Gull committed violations of the Access to the Court Records Act. This one I don't think is really, they brought this up before. I don't think this is really going to go anywhere. This stuff here. Judge Gull did remove or seal the removal of defense pleadings from the chronological case summary in violation of the Indiana Supreme Court administrative rules. She did remove the Franks hearing and the Franks pleading, the memorandum, the 3 affidavits, the affidavit of an accused leaker, and most recently an affidavit signed by the defense investigator, Suzanne Mueller, and incorporated the request for transfer. By secreting pleadings from the docket, without following the ACR rules, Judge Gull allowed violations of public access. Because those acts have shielded documents, these actions demonstrate a lack of impartiality and fairness. Judge Gull engaged in additional violations of Access to Court Records Act. Let's see here. The judge issued an order noting that Rozzi's withdrawal, albeit forced from the case, and struck from the record pleadings filed by defendant Allen. Any authority the court had to strike substantive pleadings from the record stemmed from the court's reversible error. See, the Indiana Supreme Court order, yes. She struck a bunch of stuff, and that was an error. Terminating the client relationship between Allen and Rozzi, despite Allen's objection. The court demonstrates the court's inability to remain impartial and further demonstrates this court is engaged in judicial conduct, which public confidence in the independence integrity and impartiality of the court has been undermined. Judge Gull fails to address her administrative duties. Actually, hold on here. Where are we at on this? There's a rule on court accords and make it sound very serious. Yes, well, apparently not to Judge Gull. Not to Judge Gull. She can do whatever she wants. Yes, Judge Gull says, I was elected to read, not to read. Aaron says modern pagans are just atheists who didn't think Hitchens was enough of an asshole. Fair enough. Goalie 171 says that's not docking. The elephant walk's not docking. It's like it's docking. Lynn GMB says the defendant's attorneys abandoned their client. No, they did the best they could in that situation. Bailing out the way they had to, I think, was the right call. They were left in a bad situation. They did what they could to protect their client. I think it was the best option. I would have done it the same way they did it. So, I would have 100% done it the way they did it. That guy says Karens never take their foot off the gas. She won't recuse herself. Yeah. And yeah. I don't think so either. I don't think she's going to be forcibly removed. Alpha says that's new to me. I hadn't heard about that. Yeah. Where are you guys? Are the Odins going to burn a Wicker Man? I don't know. They might run through a cornfield backwards with their pants down, though. I know they might try that. So where are you guys at here? That's a shame. Yeah, you're right. I mean, the judge's exact quote was, "I will not let them represent you." Yeah. Yes. So. Yes, Eric. Yes, she basically took a giant shit all over this case for whatever reason, and I would love to know. I would love to know what in her mind, being a great scholar and jurist, she decided just to like rub her asshole all over it. But hey, you know what? She's a judge. She's smarter than me. Baldwin submitted his first billing invoices on May 19th. Okay. Baldwin staff will settle communications concerning Judge Gull's failure to sign off on payment to Baldwin. As the months passed, those communications were basically ignored. The Carroll County auditor said they would pay the bill as soon as Judge Gull sent them an order, but they had not yet been sent in order. Holy shit. Finally, Baldwin sent an email to Judge's staff essentially begging to be paid. Eventually, Baldwin's bill from May 19th was paid in full September 18th. Jesus Christ. Only a few days after Carroll County received an order from Judge Gull, but almost 4 months to the day the bill was tendered. Attorney Rozzi submitted his first invoice on May 10th. They weren't paid until September 19th. Since then, Judge Gull has failed and refused to authorize other payment invoices submitted by Rozzi in this case. Rozzi submitted 2 separate invoices, one for his own services to Allen and a second for administrative expenses reimbursement. That must be how they do it there. I don't know. Here in Ohio, you'd file it all as one thing. No action was taken on the invoices up to and including a January 5th, 2024. On this day, Rozzi reached out to Judge Gull's court staff through email and provided summaries of various outstanding invoices that had yet to be processed. I mean, this is going to be tens of thousands of dollars. These invoices included from Attorney Baldwin, which were submitted in early December. And that's the thing. Even if they were removed, they still have the right to file for expenses. Also yet to be processed. 4 days later, having received no response from the court, Rozzi sent a second email. The court staff response was that the 3-month-old invoices had been forwarded for review. 1 day later, Judge Gull's staff informed Attorney Rozzi that several invoices had been approved and were forwarded to the Carroll County clerk for payment. Several invoices were paid, including the invoices submitted in early December. However, as of the date of the filing of this motion, Rozzi's invoices submitted 3.5 months ago remain unpaid. And it's not like the judge is paying out of her own fucking pocket. Judge Gull's refusal to process the invoices in the normal course of business demonstrate a rational inference of bias. It does. Her prejudicial behavior regarding even administrative matters, making sure they get paid for the hours they bill. Because these guys have to bill their hours. They bill, probably by fractions of an hour, and they have to submit a bill and get paid for it. Furthermore, on August 8th, Allen's attorneys requested the transcript from the June 15th hearing, which they requested he be moved out of Westville for reasons important to the defense. Yes, so he doesn't die. Nearly 6 months have passed, and the defense still has not received the transcript from the hearing. And they're entitled to transcripts to be prepared at no expense to Richard Allen because he can't afford it. Once again, it's another failure to provide a transcript. That's another example of her contempt of the defense. Fuck me. These guys are going hard. I give them credit. And now we're okay. Judge Gull failed to protect the accused. Oh, I know we're already gonna love this one. Chat, we are gonna love this one. Here we go. Defendant Allen's unique and unusually burdensome detention circumstances have been a concern of his defense team since he was shipped off to the state penitentiary only a month or so after his arrest. These concerns were immediately brought to the attention of the court by way of both in-chamber communications between Rozzi and the court, as well as emails between Rozzi and the court, offering up a reasonable solution to the problem. After the court declined to take precautionary action, the defense team filed an emergency motion to modify the safekeeping order. The court's response to the emergency request was to set the matter for hearing on June 15th. See that? There's a bit of a difference there between those two. 2.5 months after the emergency motion was filed. In the interim, Westville Corrections Institution's inmate Robert Baston filed a pro se letter with the court corroborating some of the concerns regarding the detention circumstances surrounding defendant Allen. The defense subpoenaed inmate Baston to the June 15th hearing. Rozzi perfected service of the subpoena with the assistance of the Department of Corrections through a staff attorney. However, on the morning of June 15th, Judge Gull in her chambers informed Rozzi and Baldwin that she had released Carroll County from executing the subpoena on inmate Baston due to his resistance being transported by IDOC staff members. It's nice she told them the morning of, not beforehand, to prepare. Great job, Judge. Great job. Great job. A hearing on the defense motion was then conducted, and thereafter court issued an order dated July 19th, so almost a month after that, denying the defense motion to move Allen, and in fact suggested in its order the evidence submitted did not support many of the allegations advanced by defendant's counsel because the witness wasn't there. Although now I wonder what she's going to say because Scremin and Librato filed something saying, oh my God, at the jail, it's a fucking madhouse. These fucking odinists and all this shit is true. I wonder how Judge Sugar Buns is going to deal with that now. Is she going to say, they're all incompetent. I'll be the attorney to represent Richard Allen. No attorney can do it better. I'm sure she's going to handpick the ones that are saying, Judge, is fucked up. I'm sure she's just shaking and just her teeth are clicking together. How dare they? In paperwork filed with the court on June 20th, but sealed by the judge until November 2023, and only unsealed after the filing of a writ of mandamus against Judge Gull, It was revealed to the public that Judge Gull or his staff chose to communicate with the state's witness, Toby Lazenby, concerning inmate Basson's unwillingness to attend a hearing. Uh-oh. 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 That's not good. Chat, that's not how that's supposed to work. Uh-oh. You know, some might call that witness tampering. Some might. You might not. I will. I'll call that witness tampering. Legally speaking, the witness had no choice but to appear, and Carroll County had no choice but to honor the subpoena. And that's true. It's a subpoena. It is a court order. You don't get to like if you called me as an attorney and said, "Hey, Sean, I got a subpoena. What do I do?" All I can tell you is a subpoena is a court order, and if it says you got to be there, your ass better be there. Now, are there times where if you don't show up, nothing happens? Sure. But I can't tell you to ignore a subpoena. Number one, I wouldn't want to encourage that type of shit because I might, eventually I'm going to need to subpoena people who won't show up then. And you're perpetuating that. Number two, as an officer of the court, and actually the Supreme Court probably wanted to put that number one. As an officer of the court, I can't encourage people to defy court orders. But yes, the judge had no option but to honor the subpoena and transport the witness. Prisoners all over the state of Indiana are transported to hearings and trials they may not want to attend, even if the refusal to attend is out of fear that their testimony will put them in danger. The proper method to deal with the situation would have been for Judge Gull to alert both sides about the problem and then conduct a hearing on the matter so that it's on the record. Well, Judge Gull doesn't like the record, which the Court of Appeals could review later if needed. Instead, Judge Gull, either directly or through her staff, opted to leave the defense completely out of the equation and issued an ex parte off-record ruling advising the Carroll County Sheriff's Department and the Westville Correctional Facility to leave the witness at Westville, thereby ignoring a valid subpoena prepared and properly served by the defense for a witness that was expected to support the defense, asserting Allen's treatment at Westville. Yeah. I'd argue that's sanctionable conduct. Even if it's not witness tampering, this right here is sanctionable conduct. And I hope to God somebody in Indiana is dropping a fucking dime on her. This is not acceptable. This is not acceptable. I mean, this whole thing. I'm joking like, wow, this is witness tampering, but yeah, holy cow. I can't fucking believe this. What kind of fucking judges do you have running around Indiana? Holy Jesus on a cracker. This is, yeah, this is, POV walks, I can't do that one. As much as I'd like to say that, that's not, as an attorney, I can't encourage that comment. It's okay to write it, I just can't highlight it. To anyone on the outside, this looks bad for the judge. She just looks petty and vindictive. She looks like a fucking psychopath. She looks like she's power tripping. Das Boot says sneed. Oh, this judge is sneeding hard. That's a shame says, that's not how a subpoena works? No. Yeah. Oh. C. Souter says, I hope things are more happy over here than at MLS. Well, we're dealing with Judge Gull, a judge committing crimes and breaking the ethics rules. So yeah, that's fun. Pam says, you missed MLS's last stream. What? Oh no. Huh. I'll have to look into that, but holy cow, hope everything's all right. Yes, that's a shame, says subpoenas. How do they work? Tina Reynolds said, so this is the Carroll County accident. Yeah. Oh. And Ariel, this is right. The judge said, "Oh, never mind, it's fine. He doesn't want to come. He doesn't have to be here." And then turns around and says, "You defense attorneys lied because you didn't have enough evidence." Because she told them not to come and took away a bunch of their evidence. I know. It's brilliant logic by Judge Gull. So. All the jurors will be correctional officers from that prison. Yeah. Yeah. Patty says, "Why didn't the Supreme Court order her removal?" I think they're trying to figure something out here. Because that's a nuclear option for them. They would rather to give her a chance to do it the right way. Because there's a process. They can file for her disqualification, and then if she doesn't do it, it gets appealed up the chain, and then they can nuke her boots off. That's why, mainly. They're trying to avoid doing anything drastic if they don't have to. They already did drastic enough action by putting the attorneys back on. That's a once in a generation thing. So they've already gone out of their way. That's a shame, says the situation is grim. This would. Yeah, but you know what? These guys are fucking reveling in it, and I understand it. So they'll be all right. D. Marie says, "I missed the beginning. When is this motion being heard yet?" It has not been set for hearing yet. Has not been set for a hearing yet. So it has not happened. Okay, so let's keep going though, because this is fucking brutal. But I'd argue this is witness tampering and also sanctionable conduct. I don't know how this isn't. Because if I did this as an attorney, I'd expect to lose my ticket for a while, possibly. I don't know how she's not going to walk out of this. In summary, Judge Gull released a material defense witness from a properly served subpoena and then claimed the defense team failed to meet its burden of proof up to the allegations when it was Judge Gull that prevented the witness from testifying. Judge Gull's actions were prejudicial, and that her actions usurped Allen's ability to prosecute his own emergency motion, which is otherwise known, yes, as a refusal of compulsory process. And that's the neat part, because when you enter a plea, you're advised of your rights that you waive under, as part of your plea, your constitutional rights. You have the right to a trial, whether to the bench or to a jury. You have the right to present your own witnesses and evidence. You also have the right to cross-examine all the witnesses and evidence presented by the state. The state has to prove your burden. The state has to prove your guilt beyond a reasonable doubt for each and every element of each and every offense you're charged with. That burden solely lies with the state and never shifts to you. You have the right to remain silent. You also have the right to testify. But if you decline to testify, your silence cannot be used against you, and nobody can make note of your silence in a negative way. Not the jury, not the state, nor the court. You also have the right to compulsory process, meaning you have the right to issue subpoenas and force people to show up and testify on your behalf. Meaning if there's a witness out there who could save your grits, you can bring them in, even if they refuse to show up. Your Honor, that witness is material to our defense, and the court, if it's material enough, the court will send out the police and go hunt that fucking person down and drag their ass into court and make them sit there. We saw that in the Theodore Edgecombe trial. There was a material witness that the prosecutor put in jail for a couple of days. It happens. But those are your rights. Those are your constitutional rights. And the judge fucking shit all over them. Yeah, Judge Gull's behavior exhibits a rational inference of bias and prejudice. It exhibits that she's a fucking psychopath. She doesn't care. Furthermore, her actions violate Rule 2.3. Yeah. Judge Gull's continuing and ongoing failure to protect the accused. Judge Gull's exhibited a lack of concern and taken no action to protect the physical and mental health of the accused. On 2 different occasions, the court has been asked to order the removal of Allen from Westville Correctional Facility and place him in a less restrictive and healthier environment, as he's a pretrial detainee. This court denied both attempts. At times following these denials, the court has taken the position that the allegations offered by defense counsel weren't true. Most notably, the court accused Rozzi of misrepresenting the truth about his detention circumstances and used this as support for her finding that they engaged in negligence in their representation. And I'm glad that they fucking cite this. Okay. Allen's replacement attorneys filed a 3rd motion requesting his transfer. The allegations in the motion address ongoing connections between the Odenites employed by IDOC who have been in contact with Mr. Allen. Former counsel Scremin actually offered up a photo of one guard who was so bold as a tattooed Odenite symbol on his face, while knowing his Odenite connections had previously been called into question in the formal pleadings. In addition, there's new claims that Allen continues to be detained and shackled like Hannibal Lecter unnecessarily, and now has been moved, apparently, without any judicial involvement, to a facility 233 miles from his replacement counsel, Scremin and Librato. Yeah, like he has been moved. The court takes no action to protect Mr. Allen. This is not an adversarial matter or an issue. The state should be an uninterested party. There's no need for the introduction of evidence to support these claims. The court has absolute jurisdiction over his detention circumstances. She does. She has absolute jurisdiction over that. She can order people from the jail to show up. Why is he being mistreated? What the fuck is going on? She also sets his bond and conditions a bond. It would be entirely appropriate for the court to err on the side of caution and engage in remedial measures to ensure Allen is being housed in humane under circumstances for a pretrial detainee. Because jail is different than prison, and he should be treated like a prisoner. Because he's still an innocent man. He's still presumed innocent. It would be entirely appropriate for the court to order the detention of Mr. Allen at a facility close or near his appointed attorneys, so they would have the simple convenience of communicating with him in person and under reasonable conditions, without the necessity of lengthening sojourns each and every time they desire to meet with Allen to prepare his defense. Attorney Rozzi even arranged for the Cass County Jail, which is a county in Indiana neighboring Carroll County, literally a 2-minute walk from his office, to keep Allen in pretrial detention. Now, that's impressive that he worked that out with his local sheriff. That guy has a really good relationship in his community with the court, and that's a good attorney that he can work something out like that. This exchange occurred in an email from Rozzi to Judge Gull. Oh, wow. Rozzi to Judge Gull and the prosecutors and the attorney, as well as the sheriff Schroeder, on February 8th. So this has been set for a long time, and she's like, no, we're not doing that. This request was denied as Judge Gull sided with the Carroll County Sheriff's Department due to its confusing claim that the sheriff would have difficulty transporting Rick Allen 20 minutes from Logansport to Delphi when it was taking much longer to transport him from Westville to Delphi. Yes, so the sheriff's like, we can't drive 20 minutes. We can drive 5 hours, though. Hoo-wee! Or maybe they said, we can drive 5 hours, but not 20 minutes. And Judge Gull said, well, that sounds like very compelling testimony. I mean, I'd like to say she's just a Karen, but I also have a question. Is she, like, mentally retarded? Yes, Judge Gull, I think you're, like, are you mentally retarded? Because I can't tell the difference right now. You're either a very malicious woman or you're borderline fucking, like, nah, like, I'm not even saying, like, autistic, because, like, you're not, just, like, retarded. Like, I like pancakes on my waffles. Like, retarded. The court's refusal to intervene is prejudice to Mr. Allen. The court's refusal to intervene violates his Sixth Amendment right to present a defense and runs afoul of his due process rights under the state and federal constitutions. I would also point out this probably violates his Eighth Amendment right against cruel and unusual punishment. If he's being held in solitary in a maximum security prison, pre-trial, is subject to all these butt-fucking Odinists. That's right, I called all you Odinist homosexuals again. Show up at my door, though, and spear. We'll probably shrink in the cold. Especially after it was proven by the new attorneys he was guarded by practicing pagans and Odinists when evidence and allegations exist the Odinists were involved in the murders. It provides a rational inference of bias. Yeah. Judge Gull's treated the prosecution more favorably. Oh, entirely. I don't disagree, but these guys are on fucking fire. This is just brilliant. Throughout the entirety of the Franks memorandum, the defense detailed and provided evidence exposing false and or contradictory sworn testimony by law enforcement and even the withholding of exculpatory evidence by the prosecution. That's normally a big problem, but not apparently to Judge Gull. Nope, that's fine. That's all okay. Judge Gull did not have to read too far into the Franks memo to find these intentional acts on the part of the state as alleged by defense as the most egregious as the intentional behavior of the state is referenced in the first 25 pages. The state of Indiana was continuing to provide large quantities of discovery even into October, nearly 10 months after the attorneys entered their appearance, causing Rosie and Baldwin to seek a discovery deadline. Despite the state's intentional behavior, including non-disclosure of exculpatory evidence, which I love. McClellan's like, they leaked the pictures. You're not providing exculpatory evidence. Whoa, Judge, they're bad, man. And Judge Gull, you're right, they're bad, man. Judge Gull has focused her ire on Rick Allen's counsel for what she claimed was gross negligence. For example, Nick McClellan was in possession of a highly exculpatory document prepared by Officer Todd Click's own lawyer, which Click alerted McClellan that he was concerned that McClellan had not been informed about his involvement investigating a group of men who were involved in the murders. Evidence that third parties involved in Odinism had murdered the girls. McClellan held on to that document for nearly 4 months without turning it over to the defense. That's a sanctionable action. Jed's like, well, that's okay. Boys will be boys. McClellan's failure to turn over exculpatory documents also prevented the defense from questioning investigators about the exculpatory information during defense depositions in early August. Yeah, now they can't cross-examine them. Now they can't impeach them with their own testimony. This failure on the part of the prosecutor will require additional depositions and prolong the discovery process, and now prolong Richard Allen's right to have a trial within a reasonable amount of time, because now this prosecutor dicked with everything. And if it's not the prosecutor trying to fuck him in the ass, it's the judge trying to fuck him in the ass. Yeah, McClellan, I hope you're seeing this. You're a fucking scumbag. People like you are a bigger threat to America than ISIS will ever hope to be. McClellan's failure to overturn exculpatory documents is accurately detailed in the Franks memorandum. Despite these truths, Judge Gull has never, not one time, chastised McClellan for these wrongs. Oh, I'm sure Judge Gull has never found a prosecutor in Wiener she can't be satisfied with. Judge Gull never told McClellan his behavior appears intentional or grossly intentional, or at least grossly negligent. Ooh, nice. Judge Gull never indicated her belief that McClellan should be replaced, nor did she ambush him in an in-chambers meeting after allowing cameras in the courtroom to tell him that she was kicking him off the case. In fact, on page 16 of the transcript that the Indiana Supreme Court ordered Judge Gull to release, wow, they are really fucking rubbing that in her face. Judge Gull even states, I am not accusing the state of gross incompetence and negligence. I am finding incompetence and negligence with you. What a fucking cunt. Maybe that's what the C stands for. The fact Judge Gull is solely focused on her ire on the perceived belief that Rosie and Baldwin are grossly negligent and incompetent while not addressing the prosecution's provable discovery issues and violations of constitutional rights provides a rational inference of bias or prejudice. Judge Gull engaged in unacceptable extrajudicial activities. On July 9th, someone is believed to be Judge Gull's then daughter-in-law published an entry on her own Facebook page stating, "What an honor it was to play for the girls, to play in the Libby and Abby Memorial Tournament." Was it like a laying down competition in the woods? What was the tournament? Was it a rune making competition? What a great honor it was that Abby and Libby's grandparents presented our girls with their championship finalist rings. How much fucking money did these people raise they can do that? The Facebook post is not included herein. And now this is impressive. I will give Bradley and I will give Baldwin and Rozzi credit. This post is not included as it contains photos and names which not need to be made part of the record. A copy of the post can be provided at a later hearing if necessary. That's nice. They didn't fucking air out Judge Gull's family, but I mean, fuck it. You know, if Judge Gull wants to play, guys, fucking light her ass up. Sorry, Judge Sugar Tits, you brought this on yourself. Your family got outed. Well, you could have done your job. In spite of being the presiding judge in this case at the time this message was posted, Judge Gull made a choice to publicly comment on the post with a simple congratulations. While this post may appear to be an innocuous comment to Richard Allen's counsel, it raises fair questions about whether or not a rational inference of bias or prejudice exists. Yes, on its own, it's not a problem, but coupled with everything else, well, that's a problem. Yes, one brick does not make a wall, but 5 million bricks make a hell of a wall. As the presumed relatives of Judge Gull who are mentioned in this post will likely see Judge Gull from time to time, communicate with Judge Gull, and have opinions concerning the murders of Abby and Libby, and Judge Gull must know that her relatives may have been emotionally impacted by their involvement in the softball tournament. It was a softball tournament, not like a lying down tournament. Especially from interacting with Abby and Libby's grandparents, yet knowing all of this, that Judge Gull will be challenged with resolving evidentiary and procedural disputes in this case, she chose to comment on the post. In 2013, the American Bar Association issued Formal Opinion 462, entitled Judges' Use of Electronic Social Networking Media. While the ABA acknowledged that social media can be beneficial, judges were cautioned to be conscious of the way their online relationships will appear to others. Under the Model Code of Judicial Conduct, and that's not adopted by any state, but states base it off theirs, judges are obligated to maintain the dignity of judicial office at all times to avoid both impropriety and the appearance of impropriety in their professional and personal lives. Judges must therefore be cautious in their use of social media, as communications, friendships can be taken out of context, can create the appearance of bias or impropriety, thereby undermining public confidence in the judiciary. Publicly commenting on a post concerning a softball tournament that honor the victims in this case presents evidence of rational inference of bias. It does. She's fucking retarded. Like, how fucking stupid are you? The timing of judicial bias, prejudice, and lack of impartiality. RPC 2.4 requires that good cause be shown when any movement for a change of judge cannot meet the 13-day timing requirement subject in Section 1 of the rule. Defendant Allen asserts the first time Judge Gull's bias was cemented in the minds of the defense, demonstrating her lack of, discerning her bias, prejudice, and lack of impartiality occurred during a phone call between McClellan and the attorneys in the court, and that occurred on October 10th. During this call, McClellan made a feeding reference, and very little hesitation, Judge Gull suggested she was leaning towards it. Okay. And then they appeared for the October 19th hearing. It was at this hearing the court staged a premeditated severing of Rozzi and Baldwin as the chosen lawyers of Richard Allen, leading to contentious and very public litigation. These claims, contained here and some of which occurred prior to the October 10th phone call, are believed by Richard Allen to be pieces of a puzzle. Yes, pieces of a puzzle. The totality of which illustrates the court's bias of prejudice and lack of impartiality. Some of the factual matters in this occurred before October 10th. The defense had hoped some of Judge Gull's questionable behavior that predated October 10th were not signs of bias. However, when placed in the context, her actions predating October 10th are now viewed as evidence of a continued pattern of bias, such as the failure to pay to the defense attorneys in a timely fashion, and the continued failure to protect Richard Allen. Obviously, neither Baldwin or Rossi had the authority to file any pleas on this case after October 31st, due to Judge Gull's forced removal of Allen's chosen lawyers. Therefore, Baldwin and Rossi could not file their motion for change of judge until after the Indiana Supreme Court placed them back on the case. Once again, they are just kind of rubbing that in there. The Indiana Supreme Court judge, your daddy. It is from these circumstances that Richard Allen asserts his claims in support of this motion for change of judge from Francis C. Gull. Affiant further saith not. Richard M. Allen, that looks like a man who's having a little bit of shaky hand too. That is not a healthy man signature. That's not good. I'm hoping he's hanging in there. Huh. Apparently this isn't notarized, but okay. Apparently that this certificate here, certificate of attorneys, that's good enough. But okay, you guys do you. Pretend we're all listening. He's about to read chat. Yes, start reading. Oh my God. Okay. Hold on here. Wow, damn it. This all moved on my own. It all moves on its own here. She looks really butthurt. Yeah, she kind of does. Let's see here. Trying to catch up. KT said she'll probably dismiss it without hearing it. I mean, you're probably right. I mean, let's be real. That's a shame, says if you haven't seen a judge get reversed because they deprive both parties of due process, we are not the same. If I haven't seen a judge, we are not the same. Well, judges in Ohio don't do this. So if you've seen that, I feel sorry for you because that's not something that's good. Does this make me a potentially criminal and just a whore doing it for pennies? At least he's in a Janny doing it for free. Yeah, I don't want to ever be a Janny, so I guess never a Janny. Never a Janny. Never a Janny. That would be rough. This judge looks petty as fuck, also vindictive. Yeah, not a good look. Not a good look. Yes, I do it for the peenies. The Minstrel King says, wait until most judges are like this in 10 years. Yeah, sadly. God, if that happens, we're truly... people are truly fucked and they won't even realize it. Dark Lotus says, watch as a presumption of innocence is torched yet again by the state. Motherfuck the state, yes. Stephen Cooper for $5 says, we really need to work on cloning so we can get Judge Borowski in every court. There's a lot of things he does right, but there's things I probably wouldn't like otherwise. Clone the judge in Connecticut for the Michelle Trakunas trial. That'd be one I'd rather you get cloned. It's Trenton says they want to bill for that overtime. Well, no, they just want to bill for the hours they've represented them because they're not getting... They have to submit their hours and get paid. They're court appointed. Zaven says she has dementia brain, maybe. Das Boot says pancakes are good on waffles, though. Well, maybe. A name of some sort said, so bad is the competency crisis that they hired an Odinist at a jail. It's at the prison system. I mean, to be fair, apparently there is a big issue in the Indiana Department of Corrections, like with prison gangs, but amongst the guards. But if you go out to like places like the LA County Sheriff's Department and you read about them, they have a massive gang problem within the sheriff's department. It's not uncommon for law enforcement gangs, believe it or not. Let's see here. Job well done says, I don't think they can not hire donors just because they're Odinists. Yes, but they don't get to run around with patches on their sleeves saying like "In Odin we trust" or have Odin like religion. Like you can't do that for other religions. So why are they doing it for this one? Sounds like a Brady violation at first look. Oh, it's a lot of Brady. There's Brady. I guarantee you there's Brady, Giglio. I guarantee there's all kinds of violations here. Mm. So, by the way, J Rock, hello. Hope you're doing well. Canada Girl says McClellan viewed privilege and material information between Allen and his attorneys via the investigation through the leak. He needs to go. I think they're addressing first things first. They're getting rid of the judge, then they're going to get rid of McClellan. So, Nico says moon runes. Yeah, it's a shame. Thing. Well, I mean, I didn't know what it was. Yes, it's a softball tournament. Alpha Fox saying it's crazy that this case from the apparently biased, vindictive judge, replete with theories of Odinism, suicide, etc., is more believable than the bullshit that Turtle Boy and Kieran Reed's attorney spout. Yeah. Yes. Yes. The real Hydra PX is the Trump wall. Yes. Make it 10 feet higher. Although when they talk about the whole thing about children drowning in a river of razor wire, I'm down on the border. That's a pretty awesome fucking idea. Like a river of razor wire. Like an entire river bed just filled all the way up with razor wire and you have to swim through it. That's a shame says, yeah, how hard is it not to just comment? Well, apparently for stupid people, it's very hard. Das Boot says Legal Eagle is gayer than a $2 bill. Yeah, he might be. Might be gay, but he's got the subs to show for it otherwise. I'm as base as a meth cooker in the hood. Well, I appreciate the sentiment. Is anyone actually listening to me, or are we just all shit posting? I don't know. It looks like you guys are talking about Nick a lot. I scared your dog with my yelling. I guess I need to wear headphones. My bad. I'm sorry, Pooch. I said rubbing. Yes, I did. Yes, it's time to pretend you're listening because I know I'm reading the chats. And Judge Gull just got hollowed out. And Nico said that was Tyler phone notarized. Yes. Yeah, she did. That is a, believe it or not, guys, that's a very scathing rebuke of a judge by attorneys. Like I said, they had those big fuck you flourishes on their signatures. So yeah. Um she's the judge looks involved in the suspicious, not just petty. Oh, I don't think she's I get what you're saying there, but I don't see it that way. I don't see it that way. It's just her own stupidity is, the police are being corrupt. The Odinists may have done it and it's covered up, but the judge is on her own power trip. It's just helping everybody else along the way. It's a conspiracy. It's an uninvolved conspiracy of retardation and corruption, and they just happen to all be working together right now. I should read the motion in a WWE theme. Yes. Oh. Das Boot saying, okay, well, some Jennifer Crumley questions. What are the chances Jennifer gets a good appeal? None. I mean, they're not going to. No judge is going to be like, yeah, we're going to let this lady out. Her son killed all the kids. We're going to overturn her appeal. They're going to be like, well, I better dust. You know what? As soon as they enter that opinion, whichever of the 3 judges sign off on that, let's say all 3 do. You know what the next thing they're doing is? I better dust off the resume. Here we go. Honey, I need to come home and do a fake interview. We got to get ready. That's what they're going to have to do if that happens, and they're not going to do that. Yes, Tilly is right. A better way, if you want to support me in a way that doesn't involve YouTube, you can join me on Locals for free for a month, the promo code criminal, and you can find out if you want to support me there at potentiallycriminal.locals.com. Yes. Thank you very much, Tilly. D. Marie says, does she have family in Delphi or something? I don't know. I don't know. So, Aaron Hack says, law enforcement gangs, they're out there. They are 100% out there. Lynn GMB says, facing sanctions halt payments to be processed and funds availability. But they weren't facing sanctions over the summer. So, that was the issue. Let's see what else we got. Ariel saying, for this unrelated question, but can anything happen post-trial when a juror says stupid shit led to their verdict? Generally, no. Unless it's, it's going to have to be like kind of the Murdoch situation where there's like an outside influence in jury tampering. Other than if like some guy was in the jury room and is bullying people like, listen, we need to convict because they're the bad guys. And, I'm going to break your legs if you don't vote guilty. Like, sure, that stuff generally doesn't count. Oh, Ronna McDaniel's resigning. Bye, bitch. Good. Oh. Let me see. I already answered that question here. Okay, trying to catch up here. How's Clyde? Is he still harassing the neighbors? I don't know. Because my door is closed because I don't know what's going on out there. Let's see here. Mermolly says, how did I become so based? I don't know. That's like asking a fish, how did you start swimming in the water? Just is, I guess. If I'm your definition of based, I don't know. Some of you guys say when I'm based, I'm like, really? If I'm based, what's your like pH scale at? Because it's not really calibrated right. The base is a glass of water. Some of you get that chemistry joke, maybe. Carrie says, I think the judge is corrupt. Yeah, she is. Chaucerian fraud saying, you don't need a formal conspiracy where interests converge. Yeah. And they're all not cooperating. Like, I know they're not all talking to each other. It's just, it's all happening to work in the right direction. So. When am I going to stand up, turn around, and crap on chat's head? That'll be for the 100K stream. So, might as well make a goal I'm probably never going to meet. So. The fraternal police is absolutely a gang, yeah. Clyde has visitors? I don't know. I don't know if Clyde's got visitors. Are the neighbors melanated? I mean, well, some of the neighborhood are. Sean has his limits to based, yeah. Let's see. Okay, I got caught up. I think there's some down here I need to grab though. Aaron actually has a question here. How does one demonstrate a rational inference? I think that's more something you would generate. Well, they're speaking legal parlance. That's a little different here because yes, actually in science you would demonstrate. They're they're pointing it out. That's just how we write stuff because we write like homos. Yes, that's a shame is right. Accusing an attorney of misconduct and not reporting it itself is misconduct. It very much is. It's Trenton saying there is also a concept in law about involuntary actions like fired versus forced to quit. There is. It's called especially in jobs, it's called a constructive termination, where they make your job so unsavory and unpleasant that you just quit because you don't deal with it anymore. Exactly. I wouldn't be surprised if that's brought up in the opinion from the Supreme Court, when they look at it. So that is actually it, guys. We're all caught up. Das Boot says, if you're so base, what is the best caliber for hunting and self-defense? Hand loading included, of course. Well, if you include hand loading, what are you going to tell me? It's like, what are you going to tell me? It's like 270 Ackley improved or something esoteric like that. I mean, best caliber for hunting and self-defense in North America would be for hunting. Well, 30-06 kills everything in North America, including grizzly bears. So if you're talking about grizzly bears and also killing men, yeah, it'd have to be a 30-06. It does everything. That would be the best round because it does everything with authority. Yes, you're right, Chaucerian. If you're going to accuse a judge of conduct, you might as well go all in. Most lawyers would avoid offending the judge in for a penny and for a pound. A lot of attorneys, and I would be trying to avoid pissing off the judge too. But in the situation, it's too late. The die has been cast. The die was already. The judge drew first blood. She threw down the gauntlet. She lined up for battle. So at that point, you have only one choice but to battle. So yes, at this point, there's nothing left to do. In other situations, this would be done a little more diplomatically. Watch the 4-person interview. There's a 4-person interview? Will we cover the Trump thing? Yes. No, I haven't seen the Detroit Free Press interview. Let me see here. Okay, so there's a Detroit Free Press juror interview. God, don't tell me this is gonna make me want to fucking hate people, because I'm sure it's going to. Oh. Friendly juror, let me see here. Do you guys have like a link or where to find this? Because I don't see it. Let me see here. Detroit. Oh, jury 4-person. Here we go. Got it. Oh my God. This is like a real person? This is like a real person? She like paints her face white? She like powder. This is a real person? Do I have a favorite historical judge? Learned Hand. Or Oliver Wendell Holmes. I don't know. Pick one. Is that Monica Rial? Yeah. There's no remote control dents in her forehead, so no. So all right, here we go. Let's listen to this. I have a feeling it's going to be depressing. It's only 50 seconds.
So tell us how it was deliberating.
It was very difficult. It wasn't an easy decision.
Lives hung in the balance, and we took that very seriously.
And tell us, was it? Did you have to convince each other? Is there anything like that where it was going maybe?
I will say both sides were well represented.
Oh, okay. Tell me your name.
Nope.
You don't want to tell your name? That's fine. That's fine.
You were the forewoman, though?
I was the forewoman.
Okay. Is there?
Was there something specific that really stuck that you guys were debating over for that many hours?
The thing that really hammered it home is that she was the last adult with the gun. And that's where I'll end.
That's your comment? That's your
my comment.
reasoning?
Thank
You dumb bitch.
Heard from Ethan. Is that change anything?
Thank you.
You dumb hoe. That's your reasoning? Lives hanging in the balance? There's only one life in the balance. And what is this with like... She got like, what, 8 pounds of peanut butter in her mouth? Did she touch the gun last? Therefore, she guilty. What the fuck kind of... She touched it last, therefore she's guilty. My God, that was dumb. Fuck, my fucking head hurts now. And she touched it last. She's a bad man. So it's like hot potato for you, honey? Is it hot? Like, her lipstick doesn't even match up on the... She woke up in the morning like... Oh, what is the... Is Goodbye Horses playing in the background while she put her lipstick on? Like... Is that how she's doing this?
Okay, so tell us how it was deliberating.
It was very difficult. It wasn't an easy decision. Lives hung in the balance, and we took that very seriously.
And tell us,
Look at that. It doesn't even fucking... Oh.
was it? Did you have to convince each other? Is there anything like that where it was going?
Also, ladies, just so you know, when you wear that ring in between, like, it looks like you're a cow and you're meant to be led around by it. There's a reason why cows have that ring. It's so they can be handled. That doesn't make you look hot.
Going maybe.
I will say both sides were well represented.
Oh, okay.
She sounds like this is really tough. Like, she either had a lot of speech therapy or something. I don't know. Or she just ate a peanut butter and jelly sandwich.
Nope.
You don't want to tell your name? That's fine. That's fine.
You were the forewoman, though?
I was the forewoman.
Okay. Is there?
Was there something specific that really stuck that you guys were debating over for that many hours?
The thing that really hammered it home is that she was the last adult with the gun. And that's where I'll end.
At the range. So she took... Ethan was at the range with him. Boom, done. So by their logic, James is innocent? Is that it? James is not guilty because he didn't touch the gun last? It's like fucking hot potato. Like, I didn't touch it. Ah, I'm safe. Is that it? Like, it's like musical chairs. It's like musical chairs. Culpability is like musical chairs. Like, oh, it's not me. Yeah, she voted not guilty to things that are not in evidence. Yeah. So, surely she dressed up like this as a disguise. Oh my God, I hope so. The bull nose ring, nothing but trouble, yeah. Yes, don't let women do public service, yes. Oh. Oh, God, that was just disgusting. That's like the goon that sells you the magic beans in the Zelda games, yeah. Need to see if she has dentures to confirm, yes. But seriously, I'm just thinking of, I'm just thinking of this as I hear it. I mean, I'm only gonna share this for a second so I don't get copy struck, but you hear this in the background as she's putting on her lipstick. Probably some dead person in her house. Oh. Jennifer Crumley must have known she was fucked all along. I think so. And I mean, honestly, she was. She was. Based for a mistrial? No. Your Honor, I want a mistrial. Why? My jurors were retarded. That doesn't count. Court of Appeals will say sorry. Sorry they were retarded. She's prepping to play with her dogs later. Yeah. Oh. Shane Chaser says, wasn't the school staff member the last adult to hold the gun, technically? Yeah. I mean, technically, yes. And thank you for the super chat. Yeah, I know that's very yeah. Yeah. Is James' lawyer going to play his interview? It's not admissible. That doesn't count. It doesn't matter. Two juries can come up with different verdicts, so they can both convict. This won't be. They can't use this as evidence in the next one. This will be entirely excluded. She's a BPD Twitter addict. Yeah. Shannon messed up voir dire. I don't know. I have the feeling she kind of got fucked and was probably like, they were probably running out of people, or this was better than the alternative she thought. Yes. Would you fuck me? I'd fuck me. Yes. She's like, would you convict me? I convict me. So. Sean, but the juror question, the judge said not to infer. Yeah, well. Sky Queen says, can you ask your defense lawyer to choose any persons without face tattoos? I mean, you can make that your strategy, but eventually you're going to like run out of, like, let's say there's 10 people with face tattoos on your jury. And like, it has to be, if face tattoos are part of the case, you could probably get them struck for cause, but you're probably going to be limited to your peremptories unless you can find out they're unreasonable or unsuitable for other reasons. So you could try, but there's only so far you're going to go. J-Rock says, here's how you win that case. 3 questions. 1, he was looking at the bullets. Diane Kelly says 10 unaffirmed jurors, God help us. No, it's 12. I thought. Steven for $5. Thank you, Steven. Says leave the 4 ghost alone. She grew up in Flint. Yes. Kimbo says I'm 10 for 10 on big trials over the last several years. Give me my attorney license. Okay. So J-Rock's number 2 is, did he have a backpack? And number 3 is, did you search the backpack for a gun? I agree. Oh. Dark Lotus for $9.99. For the lulz. Thanks, Sean. Oh, you're welcome. You're welcome. You are welcome. What happened to the gag order does not apply to the jury. The jury is done. The jury is never going to come back in. The jurors are free to discuss things. Now, the attorneys, because like Jennifer might get subpoenaed to testify or things like that, those attorneys I could see possibly being under a gag order, but the jurors can't be. They're done. They've been discharged from their duties. The judge can't put them under order. They're no longer under the jurisdiction of the court anymore. They're just random people. Again. So, like, if you're walking down the street, the court has no jurisdiction over you like that to tell you, shut up, you can't talk about a case. In this situation, they're they're citizens again. Random civilians. Amateur iconoclast for $2. Thank you. It's saying a young Mimi Bobek. Oh. Criminal Network says that jury foreman knows all about gag orders. Oof. Allegan News says got a 1776 tattoo. You're on the panel. And the prosecutor's immediately going to try to get rid of you. So get ready for that. I'm not joking. You say the words constitution, constitutionalist, libertarian, bam, you're getting peremptory challenged. You're getting excused right off the fucking bat. So don't say those words. Sunshine says it almost would have been better off with the bench trial. No, it wouldn't. The bench trial would have been even quicker. She would have got fucking convicted even faster, so no. J Rock says, because what the fuck, you were concerned about Ethan looking at bullets? Yeah. Oh. Ariel saying, I wonder if she's going to realize how embarrassed she should be. Probably not. She strikes me as an idiot, and idiots don't know that they're embarrassed or should be embarrassed. Oh. Yes. Your Honor, I think a man has a right to defend his family jury duty. Yes. That might get you tossed too anyway. So. That's a shame. Said I had an anarchist on my last panel. I wanted to be friends with her. Started talking about repealing the 13th Amendment. Are you fucking serious? Like in the middle of court, you're talking about repealing the 14th Amendment? That's awesome. Oh, that is good. Oh, that is so funny. That'd have been a hell of a discussion to hear. Did you start bartering about it? Like, I know we should really be able just to enslave people. Okay. Diane is saying, Sean, what lives were hanging in the balance as she stated? I don't know. There's only one life in the balance. Unless she thought they could come back from the dead. And Aaron saying, I know you have a job and all, but do you want to stream the James Crumley trial? I can't watch it on Law and Crime. Here's what we'll do. I can probably watch it as we go. Also, this is just a random part of 3D printed material. What we can do is I will, and it's funny, but you can show this all day long, and apparently it's okay. What we can do is, depending when it's on, yes, I will try to stream it. We may get really far behind, but I can't imagine it goes on any longer than this trial. Maybe they'll streamline it down. But to be fair, there are parts of that I'm probably, we'll try to catch up on it. Okay. But yes, I will try. J-Rock says it's hard to articulate, Sean, in chat, but you get it. A better lawyer would have gotten the not guilty. I think a better lawyer would have put on a better defense and would have been better at making points. I think so, but here's the thing, J-Rock. That jury has to live in the community. So you let Ethan Crumley's parents go. They killed those poor kids. Those 4 kids, they couldn't learn how to play. They didn't play dodgeball well enough to dodge the bullets. So they're all dead, and you let their parents out. Oh my God. There's no way those people have the integrity to say not guilty. That's a shame, saying she was so based. Oh, the slavery girl. Okay. Thought you were talking about the juror. Is that an MP5 receiver? No, it's not. It's not a part for anything. What 3D printers do I own? I own an Anycubic Cobra Pro 2. Your round trip distance to your courthouse is 650 miles. Jeez. Bella's saying, what does the DC court decision about Trump mean? Nothing. The appellate court was always going to say, always deny it. It's going to depend on the Supreme Court. So it really, that one doesn't matter. This was just this was just formal as a formality. The Supreme Court's the big one. Yes. Yes, we use that bitch to educate the room. She also made the Kanye argument. The 13th Amendment actually legalizes and enshrines slavery. Wow. Crazy case says a real lawyer? No way. I know. It's hard to believe some days. They sentenced a 73-year-old man who tried to burn down the abortion clinic. Based. $300K restitution and 5 years in prison. Aw. Yes, a small part that was not allowed in Ethan Crumley's journal said, I need to find out where my dad hid the gun. Yeah. And David says, all these kids will never wear their pumped up kicks again. I know. If you guys didn't know, the song Pumped Up Kicks is about a school shooting. Aaron saying, if the jurors said in the interview they thought Jennifer's last to have the gun, can James use that in defense? No. Nope. That is not a fact that can be introduced that way. Nope. And you can't subpoena her. So nope. What one jury said does not affect the other jury. So gunshot teacher said she saw Ethan and said it couldn't believe it was him. Well, and the principal who walked up to him said she couldn't believe it was him either. So Furby says the state has a monopoly on slavery. Yes, and violence. So Hella's saying, did I hear you streaming the rest of the trial? No, we're going to try James's, not the rest of this trial that already happened. I mean, we still got to get to Michelle Trakunis. And Michelle Trakunis, guys, finally got interesting. We're finally getting into the conspiracy to commit murder where people are destroying evidence and covering things up. So hang in there with us. It's actually getting good now. One of the guys who got offered, one of the co-defendants got offered straight up immunity. So he's spilling his guts. The fucking prosecution said it was surprising that it was him. Yes, I agree. And I think Shannon left a lot of cards on the table. She didn't throw out. She just folded. So, yeah. All right, guys. The school staff member's last adult to hold the gun. Well, they held the backpack, but yes. Yeah, I just want to make sure I got that. I already got that shade. I got the rest of your guys' stuff here. Okay. Just want to make sure I got everybody. So. All right, guys. I am going to wrap it up. It's been a long day. We're probably going to do, I'm going to try to get up time. Well, I'm at home tomorrow, so wake up. We're going to probably do future conflicts tomorrow, assuming they'll have room for me. They generally do. Hang out with them tomorrow morning, and then we'll get going on Michelle. Hella says, I'm a puppy on your doorstep. Yeah, well, I can hear Clyde actually outside the door of the studio, so that's very funnily timed. Where do I dump my fans? I don't know. Who's on right now? Is our boy Joe on? Our boy Yosef? He's on. All right, I got him. We'll do that. We'll put Joe down. Let's go here. Hold on, chat. Also want to remind you guys, tomorrow night at 7 o'clock Eastern, we'll be interviewing Kara Weinke, involved in the Richard Allen case, getting to the Supreme Court of Indiana, and involved in helping him out. And she's going to talk about what she can. But if you guys have questions, bring them in. I will try to. I'm not going to lie, but like, if you super chat in the question, I'll make sure I answer. I'll ask it to her. Okay, it'll make it a lot easier. So if you guys have questions, super chat them in. I mean, not well, yeah, I am kind of trying to grift there, so you guys will have to deal with that. But anyway, you understand where I'm going with this. So, but let me get you guys all sorted out here. That'll be tomorrow night. I'm going to get that put up right now so you guys can see it. Redirect. Good logic. Goo. Yeah, I'm going to send you guys over to Good Logic. So send you over to Joe. If you guys want to do that, say hi to him, and I will see you guys tomorrow. That's a shame. Says, do you have the link for tomorrow? I want to share. I'm going to put that together. You'll have it in a second. I got to get it all. I got to get my thumbnail put together too. So give me 1 second. But I'll get that to you. I'll actually send it to you in email as well. All right, guys. So have a nice night. And for Richard Allen, the battle has just begun, but it's gonna be raging for a while. Send us to Alyssa Clips. Nobody's on right now. That'd be funny though. All right, guys. I'll see you later.